What is a writ of certiorari for the Supreme Court? Imagine a case from a lower court that you think the Supreme Court needs to review. How does that case get to the highest court in the land? That's where a writ of certiorari comes into play. It is a formal order from the Supreme Court asking a lower court to send the records of a case for review. This process is how the court chooses which cases to hear, since it cannot review every case that is brought before it. The process begins when someone involved in a case is unhappy with the decision made by a lower court. They then file a petition asking the Supreme Court to grant a writ of certiorari. The court then looks at the petition and decides if the case involves important legal questions, conflicts between lower courts, or issues that affect the nation as a whole. The justices use a rule called the rule of 4, which means at least 4 of the 9 justices must agree that the case is worth hearing. If they do, the court grants the writ and the case moves forward to oral arguments. If fewer than 4 justices agree, the petition is denied, and the lower court's decision stands. The writ of certiorari acts as a gatekeeper, helping the court focus on cases that have broad legal importance. It allows the court to resolve disagreements between different courts or address constitutional questions that need clarification. Every year, the court receives thousands of petitions but only grants certiorari to about 100 to 150 cases. Once the court grants the writ, the case enters the courtroom phase. The parties prepare 4 oral arguments where they present their points, and the justices ask questions. After hearing the arguments, the justices will decide the case and issue a ruling. This ruling then becomes part of the legal precedent that guides future cases across the country. In simple terms, a writ of certiorari is the court's way of selecting cases that matter most. It's a tool that helps the Supreme Court manage its workload and focus on cases that have the biggest impact on the law and society. Without it, the court would be overwhelmed by the sheer number of cases, and important issues might go unresolved.